Welcome to International Law of the Sea. So in this recording there are a couple of key concepts I want to cover under the general heading of an introduction to public international law, as not all of you will have done a public international law course before, and even those of you who have, this might serve as both a useful reminder and an explanation of how the idea of sources of international law works somewhat differently perhaps for law of the sea. Okay, so let's turn to the first couple of questions I've put on today's handout, which include what are the sources of international law, what does a doctrine of sources mean, and where does the authority of international law come from? So first off, the idea of a doctrine of sources, you could think of this as H.L.A. Hart's rule of recognition. Somewhere in any system of law there has to be a rule that tells you what the rules are, a rule that allows you to identify validly made rules or properly authoritative rules. And in international law we normally start with Article 38 of the International Court of Justice Statute, which tells us the forms of law that the ICJ can look to in resolving a dispute. And principal amongst these are rules arising from treaties binding on the parties to a dispute and international, customary international law. And we'll come back to that. But two other concepts are listed in Article 38, and these are judicial decisions, the decisions of both international and national tribunals, and the writings of the most eminent publicists, so academic commentary. Now, a thing to distinguish here is those last two, judicial decisions and the writings of eminent publicists, are not of themselves sources of binding rules. They are, one way of thinking of it is there's a difference between formal sources, those aspects of the law that can create binding rules, treaty and custom, and material sources. So sources of material evidence as to what the rules are or how they might apply in a particular situation. So one of the first differences between international law and national law is there is no doctrine of strictly of precedent in international law, nor any hierarchy of courts. That said, most tribunals are reluctant to depart from their own previous decisions without good reason, and generally speaking, the decisions of the International Court of Justice are given great weight. Also on the question of publicists, this might be eminent textbook writers, but now in practice, most international tribunals are reluctant to refer openly in discussion to the writings of major scholars, in part because the system has become much more detailed over the course of the 20th and now the 21st century. However, the works of the International Law Commission, an advisory body of the United Nations that's appointed from some of the most eminent scholars in international law, the works of the International Law Commission are still treated as having great weight. Alright, but if we come back to the basic sources of international law for our purposes, treaty and custom, these have some analogies with national law systems, particularly a common law system that includes both written and unwritten or uncodified law. So in the common law system, this would typically be on the one hand constitutional and statutory law, and on the other hand the common or judge-made law. So in that rough sense, you're already familiar with a system that has both written and progressively developed rules. Now, this leads to the question of what grounds international law? Where does its authority come from? And for natural lawyers in the Renaissance and early modern period, the answer was the ultimate source of authority for international law was either God or nature. And so naturalist conceptions of international law said either these are the rules that have been divinely ordained and bind international society, or even if there is no God, right reason and pure logic should allow us to deduce these rules. That theory is, perhaps unsurprisingly, no longer in favour, and broadly the international system operates on a principle of consent. So treaties are binding in a similar manner to contract because the parties have consented to them. And at least in theory, when we come to customary international law, states have either consented to these unwritten rules or have at the very least failed to opt out. Alright, so let's talk a little more about customary international law. So this is the idea that the international legal system includes a significant body of unwritten rules. So the question is, where do these rules come from? Well, the orthodox answer before the International Court of Justice and in international law textbooks would be a rule of custom is evidenced by state practice on the one hand and opinio juris on the other. Opinio juris being a Latin tag for the idea that conduct must not only be regular to give rise to a rule, it must be carried out with an awareness or belief that that conduct is legally required. So one example given by the English scholar Vaughan Lowe is that when heads of state arrive as visitors at a foreign airport, a red carpet is invariably rolled out for them. There is perfect consistency of state practice, but no one believes that it's a legal requirement to do so. It's simply courteous or convenient. So there has to be something else other than a regularity of practice required to give rise to a rule, and that element is said to be opinio juris. Now, again, don't be misled by the Latin. The term only arose in the 1920s, but this is now called the two-element theory of customary international law. You need practice and this element of belief that a practice is binding or required. So that's where sort of the consent element of international law comes into custom. Now, the question then becomes, well, if you require evidence of these two elements, how do you find them? And state practice, in theory what states do, is actually harder to track than what states say they do. But, for example, if you're trying to answer the question, how wide may the territorial sea of a coastal state be, one way of documenting state practice might be to look to their legislation. What have states said in their national legislation is the width of the territorial sea? And then, as to the question, do they believe there's a rule of international law that permits this? One could look to what was said in the course of treaty negotiations or in statements at the UN General Assembly. So opinio juris is often easier to discern in speech acts, and one useful function of the United Nations system is it's actually sped up lawmaking both in the treaty law front and arguably on the customary law front as well, because it's much easier to document what states believe to be the law on a particular issue. Now, yes, I'll leave it at that. We'll go into sort of more examples of how evidence of customary international law can be a difficult thing to find. The one point I just make at this stage is that while there's notionally this idea of consent involved in opinio juris, it does risk being a little artificial or illusory. So I'll make that point by reference to two situations. The first is newly independent states. So the period of the 1950s through the 1970s saw a number of states become former colonial territories become independent states in the modern international system, and they were automatically bound upon independence by all the pre-existing rules of customary international law. So in that sense, the consent was sort of deemed. This was the price of admission to the club of nation states. You don't really get to challenge pre-existing customary international law. The other possibility is the concept of a persistent objector. So if a new rule of custom is emerging and you as a state have consistently, every time it was relevant to your interest, said we do not consent to be bound by this new rule, then you are not. The question becomes, at least in the case of some rules of the law of the sea, whether persistent objection is practical or possible. So let me give you an example, and this goes to one of the key techniques of being an international lawyer. Your first question as an international lawyer faced with a dispute should be, what rule is binding on both of the parties? Now, if they're party to the same treaty, that will give you a really obvious starting point. Probably won't tell you everything you need to know, but at least you'll know where to start. With custom, it might become, custom in theory is binding on every state in the world unless they've been a persistent objector. So that's quite helpful as a starting point. If you can say, well, there's a customary rule, the territorial sea has a maximum width of X, then no state may declare a territorial sea in excess of that limit. But here's the thing, what if a state is a persistent objector to a rule of the law of the sea? So historically, the width of the territorial sea was said to be the width of a cannon shot. It was a theory of military force. Then at some point in the early 20th century, states started proclaiming numerical or mathematical limits to their territorial sea, that it would be 3, 4, 6 or 12 nautical miles, but there wasn't any great consistency, which led to a number of treaty negotiations to try and resolve what the width of the territorial sea should be. Now, when practice started to crystallise around the idea of a 12 nautical mile territorial sea, a number of major naval states objected and tried to make sure that they were persistent objectors to that new rule of the territorial sea. So it wasn't binding on them. So the British Navy, for example, could say, we observe a 3 nautical mile territorial sea, and we believe that is the correct limit. Therefore, we are persistent objectors to the new rule. So the only rule other states can enforce or invoke against us is a 3 nautical mile maximum, because that is, as it were, the lowest common denominator. It's what both parties have consented to, the old 3 nautical mile or cannon shot rule. However, what does this mean if you've accepted the 12 nautical mile rule? Does that mean that the UK can prevent you from fishing or potentially restrict your navigation within 12 nautical miles of its coast? No. The UK could only invoke the 3 nautical mile rule even against states which had accepted the new rule. Now that meant that while the UK could still manoeuvre its warships perhaps more freely, it was losing control over certain issues off its coast where other states, generally speaking, had that advantage as against the rest of the world, if not against the UK. So in essence, persistent objection on this issue of the width of the territorial sea meant the persistent objectors were losing. Other states were gaining control that they could invoke against 95% of the world, and that was conferring a benefit upon them, and states that did not accept the new rule were losing that benefit. So in the end, it became impractical for a number of states to continue to object to the new rule on the territorial sea. So while objection is possible in theory, in practice it's quite rare. All right, now in terms of treaty law, we need to consider some basic rules about the interpretation and application of treaties for this course. So the key elements of the Vienna Convention on the Law of Treaties, 1969, and I suggest that for this course you get, if at all possible, a paper copy of the UN Convention on the Law of the Sea, and happily most fairly old statute books will contain a copy of UNCLOS, but also useful treaties like the Vienna Convention. So the two sections of the Vienna Convention we'll look at most commonly will be Articles 31 and 32. Article 31 sets out a general rule of interpretation, and Article 32 governs when we can look at supplementary means of interpretation. Now, the as a general matter, when we're interpreting a text, there's really two approaches one can take. One can look to the ordinary meaning of words in their context, a sort of literal or textual approach to interpretation, or one can seek to give effect to the object and purpose of the legislation, the instrument, the document, the treaty. Article 31.1 of the Vienna Convention helpfully tells us, a treaty shall be interpreted in good faith in accordance with the ordinary meaning to be given to the terms of the treaty in their context and in the light of its object and purpose. So the international rule is actually that you get to employ both literal textual interpretation and also have regard to object and purpose. Now, if those two techniques aren't enough, you can then have recourse to supplementary means of interpretation. Now, the thing I just want to draw attention to here is Article 32 says that you can have recourse, for example, to the negotiating history or the preparatory works of a treaty to assist you in interpreting it if, in one of three circumstances. In order to confirm the meaning resulting from the application of Article 31, the ordinary rule, or to determine the meaning when the interpretation according to Article 31 leaves the meaning ambiguous or obscure or leads to a result which is manifestly absurd or unreasonable. Now, what most people take away from Article 32 is to say, well, you get to look at supplementary means of interpretation if it's absurd or unreasonable or obscure. But actually that phrase, to confirm the interpretation arrived at, is really important, because in practice most international tribunals will always look, or will very frequently look, at the preparatory works and negotiating history. Because if the negotiating history doesn't confirm the ordinary meaning, then it might actually reveal an ambiguity, for example. So recourse to Article 32 is actually more common than a first reading of the text might suggest. Now, the next thing we need to consider is the relationship between treaty law and customary law. And this is slightly complex, but it's relevant because there'll be situations where not every party to a dispute is a party to the convention you want to apply. For example, the UN Convention on the Law of the Sea. So it would be very helpful if some of those rules were also customary and therefore binding on the world in general. Now, there are three words that might describe the relationship between custom and treaty, or that might usefully describe that relationship. And they are codification, progressive development, and crystallization. So codification is a reasonably easy idea. You might have a body of unwritten but generally accepted rules on a topic such as the law of the sea, and states decide it would be helpful if those rules were clarified and reduced to writing. That is codification. So you're taking rules perhaps expressed at a slightly high level of generality and trying to reduce them to writing for the sake of certainty. Codification. The next possibility is progressive development. That you have some broadly understood rules, but they're not really sufficiently detailed. New situations are emerging that they don't cover, so you would like to both clarify the rules and extend them somewhat, particularly to cover new developments. That's called progressive development of the law. And progressive development and codification are two of the functions of the International Law Commission, the body of experts I was talking about before. And they are frequently tasked by the UN General Assembly with drafting articles on a particular topic suitable for adoption as a treaty later. And we'll see that when we come to discuss the Geneva Conventions on the Law of the Sea. The final possibility, though, is crystallization. And this is a situation where states are debating whether a new rule would be useful, and that debate occurs in the course of drafting a treaty, and in fact, consensus around the existence of the rule crystallizes before the treaty is concluded. Now, let me give you a particular example. It's an established part of the law of the sea that states can proclaim a 200 nautical mile exclusive economic zone. That's obviously very useful if you're a state. Control over fishing, control over oil and gas exploration. That's valuable. Now, there was a lot of debate about whether the law of the sea should recognize some such zone. Some states called it a patrimonial sea. other ideas were being thrown around, particularly as to how wide such a zone should be. And in the course of the negotiations for the UN Convention on the Law of the Sea, it became apparent, because these were very long-running negotiations, they ran over 9 years, it became apparent that states were going to agree that the law of the sea included such a zone, and that the width of such a zone was going to be 200 nautical miles. Now, before the treaty was concluded, many states started enacting in their domestic law a 200 nautical mile exclusive economic zone. Now, doing so expresses a belief that doing so was legal. But what supports that legality? It couldn't yet be the treaty because the treaty wasn't yet concluded, let alone in force. It could only be that states believed that they were now supported by a customary rule. So sometimes a customary rule is really, or the origin of a customary rule is really when states, as it were, proclaim a potential rule to the world and see who joins in. And if everyone ultimately accepts that the new rule is beneficial and useful, like the 200 nautical mile EEZ, then it may pass into custom. If other states don't accept it, then the first mover risks acting illegally. In any event, that's where I'd like to leave our preliminary discussion of custom and treaty law, and we'll be applying this in a number of exercises in class. And in our next video, we'll look at questions relating to the origins of the UN Convention on the Law of the Sea, on which I also have a separate and more detailed YouTube clip. All right, thank you for your attention. I hope you found this useful.